Welcome to the latest Evershed Sutherland Legal Insights podcast.
Welcome to the next episode of our Data as an Asset podcast. We have a stellar lineup today. We're going to be focusing on competition issues and disputes in relation to data, and there's a lot of intertwined issues that we have in this topic. Just to kick off, and I'll just introduce the protagonists on today's call. We have Daniel von Brevern, who heads up our German competition, trade and foreign investment team in Germany. James Hyde, who is our international head of telecoms and TMT disputes. Matthew Howse, who's head of disputes in Northern Ireland, and Aisling O'Hare, who rather impressively is dual qualified in both Northern Ireland and England and Wales, but focuses on sort of commercial contracts, IT and data protection. What we're seeing is that whether it's personal data or data, confidential information or trade secrets, we're seeing a number of different disputes arise in transactions with clients or that come up in due diligence for M&A and corporate transactions. Daniel, just kicking off with you from a competition perspective. I understand there's been a number of regulatory initiatives, both on a European and national level, aimed at both data and competition law. Can you briefly give us an overview of what that is?
Yeah, sure. Thank you very much for having me. I mean, in the last decade or so, I think competition regulators and other stakeholders felt that the traditional competition law, the traditional antitrust law, was longer really suited to deal with the challenges of data, of the digital economy, and essentially all things data, really. And it does not happen very often these days, but in this instance, actually, the German legislator was the first to adopt new legislation in 2021 by amending the existing competition law and introducing specific provisions aimed at what we would today call gatekeeper and the handling of data of these gatekeepers. On a European level, we have obviously the Digital Markets Act, which became really effective 1 year ago in May 2023, which is essentially a new law, a competition law 2.0, if you want so, and again, very much aimed at gatekeepers and how gatekeepers do handle data. And in the UK, I mean, I guess I'm not really the expert here on the UK, but as far as I know, we are seeing the Digital Markets Competition and Consumer Bill currently in the legislative process, and my understanding would be that it is expected to come into force in the second half of 24. And again, it's at least similar to what we are seeing in the DMA on a European level or the German pendant.
Thank you. And to what extent should we expect these new regulatory instruments, such as the Digital Markets Act, to have an impact on private litigation?
Well, that's an interesting question. It is very clear that first and foremost, these new regulations are aimed at giving regulators additional powers to intervene in digital markets, to intervene with respect to gatekeepers and the handling of data. So private enforcement, as we would call it in the competition law context, so private litigation comes at most second, I would assume. For example, the Digital Markets Act, the DMA, does not provide for any specific provisions on how the DMA can be enforced by companies or individuals. So it's really giving powers to the regulators. And that's what we have seen in competition law, to be honest, which traditional competition law, which from the outset was aimed at giving regulators the means to intervene in markets. And then private enforcement very much developed over time. And that is also something which I expect to see, at least for the DMA and the German pendant. It will be privately enforced. There will be private enforcement. There will be litigation. It will be based on what is available in the general litigation context. There will be some trial and error in the beginning. And it will certainly take some time before the DMA can be firmly established. And just on a side note, I think the UK bill does include some provisions on private enforcement and collective actions. So it might be slightly different in the UK compared to on a European or German level.
Thank you. And I know there's actually a separate podcast series specifically about new UK DMCC bill. So please keep a close eye out for that. But just another question I want to ask Daniel, and we on these podcasts we're always looking for trends and sort of horizon scanning and to see sort of where we see things moving. Have you seen? I mean, we've seen over the last decade a significant increase in antitrust related damage claims, in particular by way of collective actions. Is this something we can also expect for data related antitrust claims as well?
It is indeed true that that we have seen an increase in collective damage claims, and I guess most prominent is the litigation in relation to the truck cartel, where various truck manufacturers were fined in 2017 by the European Commission, a fine of several billions. The cartel covered Europe and the UK, and ever since we've really seen thousands of private damage claims brought against the truck manufacturers, pretty much everywhere in the EU and the UK. And an important part of the claims is brought as collective actions, very often initiated and funded by litigation funders. I guess it would be difficult to find a litigation funder these days who's not involved in the truck cartel litigation. Now, a key role obviously plays whether and to what extent national law does allow for collective actions. We are certainly seeing in the truck cartel collective actions in the UK and in Netherlands, to some extent also elsewhere, for example, in Germany. But it's also worth noting that none of these collective actions so far has actually ended up with a final judgment. Yeah, so we are 7 years into the litigation, and really no proper outcome on the collective actions. In terms of now coming to data and the DMA, are we going to see similar developments? I think so, at least in theory. I mean, if a gatekeeper infringes the DMA, somehow handles data as the gatekeeper should not, and infringes the DMA, that is most likely to have an impact on a large number of users, companies, individuals, whatsoever. So it seems to be a good case for collective actions. In practice, I expect that these collective actions will face the same difficulties and hurdles we are currently seeing in competition law and antitrust law. And there are many difficulties and hurdles. So at the very least, I'm expecting to see this kind of collective actions, but I'm not expecting quick wins in the near future.
Phil, I mean, I would add to that. I mean, certainly in the UK, we are seeing claims brought with the data aspects in the UK CAT, for example, and being formulated in the CAT, just given the difficulties that some of the claimant firms have been having in the UK courts in relation to collective actions. So, and that will definitely continue, but also it will ebb and flow, I think, in the future between the CAT and the courts, where claimant firms are being creative about how they bring and formulate those claims. So I think we definitely will see more of it, and we're already seeing it.
Thank you very much. And I'm always looking for appropriate segues to sort of get other people talking on the same issue. So I'm going to move from competition and so it's competition in a regulatory macro environment to restrictive covenants and whether they are enforceable in things like employment contracts when you've got sort of employees moving from one organization to another, as that's obviously often a concern. Matthew, if I may come to you, I suspect I probably know the answer to this question, but I think it's such a live topic, and we've had a number of issues and matters where we've been advising on this. Have you come across issues where an employee or even a contractor is leaving their current employer in a contentious scenario? And what sort of issues arise in relation to the data that belongs to the employer and what's the employees?
That was a very neat segue. So well done. Yes, I mean, definitely in Northern Ireland, rather like the rest of the UK, there was a real glut of those kind of senior level moves, sort of as we sort of emerged, I suppose, from the the real dark days of the COVID era, that infamous war on talent that we all heard about. There was one we had in particular, actually. It was an interesting one. So it was a global manufacturing client that's headquartered here in Northern Ireland, and there was I think he was a senior sales guy, not a director, but a senior guy who was basically moving to a very similar competitor, also a global manufacturing organization, also headquartered in Northern Ireland. This chap was put on gardening leave. All seemed to be progressing fine as he was sort of running down the clock on his time with our client. The client did a bit of a cursory check of the laptop and phone, company devices that this guy had. It was realized that there were some files on there that looked like they shouldn't be there. They were essentially client confidential information. He had no reason to have that stuff sat on these devices. So then that led to a bit of a worry and a concern. We became involved. It turned out that this chap was communicating with his future employer, sending them all sorts of customer information and indeed contacting customers of our client as well. It blew up massively. There was an injunction that we acted on. It all got rather hot and heavy, it's fair to say. Forensic IT guys were brought in from outside, and then really we were into that pretty tricky territory actually, because yes, he had company data on his devices, which he shouldn't have, in breach of his employment terms, but there was also clearly things like Google Mail accounts, his own accounts, and there were some rather sort of thorny questions raised as to what the client could do in terms of effectively searching that kind of material. We were obviously very mindful of the client not breaking the law, the criminal law as well, breach of Computer Misuse Act and different things like that. In the end, we managed to kind of strike that careful balance of not effectively intruding into his personal information, his personal space. But it was a tricky one to navigate. He was clearly banged to rights, and that's how it ended up in the end. But we had to be very careful along the way.
Yeah, I have heard of instances where, for example, if you're trying to make an ex parte application and you've done something like that, and you thought you were doing a good investigation, but you perhaps looked somewhere where you shouldn't have looked, you then sink your ability to apply for an injunction, which is not a good place to be. So I think having some careful support and advice before, although all the IT forensic people would always say, don't touch anything, that don't turn it off on whatever, just call us to preserve the evidence. But
absolutely, and it was a bit tricky, that one, because arguably there had been some steps taken already by the time it came to us. So we were, as I say, just very, very carefully navigating the right side of the line on that one.
Yeah, I know we got involved in the data protection team on those sorts of issues, but there's trade secrets to think about, confidential information, copyright databases in the information that might be taken, contractual restrictions, what it may be used for, et cetera, et cetera. And I suppose in the age of AI now as well, there's disputes around what data is being used for, training models and what have you. So although it might be a bit difficult to people, an employee to take that much information, but I suppose any damages would also be based about what it's used for when you take it. But just coming specifically to, I suppose, practicing in Northern Ireland especially, because I know there's all sorts of very, very interesting jurisdictional issues, post-Brexit or otherwise, but do you come across sort of jurisdiction and choice of law disputes in terms of where a claim may be brought? Because I think it's probably a particularly interesting part of the world in that respect.
Yeah, no, absolutely, and I'll sort of skirt around the top of it almost, because you could talk for hours on this, which probably would have people nodding off. But it is interesting, and it does come up often, I have to say. Northern Ireland being, as it is, part of the United Kingdom, but also being its own separate legal jurisdiction. These issues come up all the time. You'll have contracts that are perhaps slightly loosely worded, that don't quite refer to the choice of law correctly, or where claims should be brought. As between Great Britain and Northern Ireland, the CJJA 1982 Act comes into play, and there can be some really tricky decisions actually to try and decide where the best place or the right place is to bring a claim. Obviously on this island as well, as you've said, Philip, Ireland North and South, again some tricky issues, and again post Brexit that has added perhaps a layer of complication as well. The place of the defendant's domicile, where the defendant actually is, often sort of tends to be the key driver. There are exceptions to that, and then, as I've mentioned, choice of law clauses, those come into play as well. We've got one at the moment that we're looking at, and we're into that slightly awkward battle of the forms territory, which terms and conditions prevail, etc., etc. So yeah, it is a thorny point, and it does come up for us surprisingly often, actually.
Thank you very much. So, Aisling, I know you work closely with Matthew and others, especially around sort of commercial contracts and drafting type issues in the light of data and data protection clauses. Are there sort of particular things that, I know I haven't got so long to sort of cover everything on this call, but just particular things that people should be aware of in the context of disputes and data?
Yeah, absolutely. Yeah, like given the significant value that can be derived from data, it is an area that we are advising on more frequently. So as you know, the sharing of data can take many different forms, so whether that's a reciprocal exchange of data or whether it's one party making data available to the other. And the way that you share that data will then shape the way that you draft your contracts. So generally speaking, there is no one size fits all approach when it comes to your contracts. But that being said, there are generally a number of areas that you need to think about. So firstly, there are the obvious data protection issues, and most jurisdictions, particularly in the UK and the EU, they'll impose stringent limitations on the sharing of personal data. So you need to think about whether personal data can be shared, does the agreement allow it, and could it be anonymised instead? And then secondly, and setting aside those data protection issues, not all data that's valuable to your business will be personal data. So there are a number of other areas in your contracts that you'll need to think about. And these include things like your data rights clause. So, who has control over the data, who can access it, who can use it, and what can they do with that data? Also, as you said, really important to look at confidentiality and security provisions. And then finally, it's also really important to look closely at those liability and indemnity provisions in your contracts to determine what you may be able to recover in the event of unauthorized use or disclosure of that data. So those are just a couple of examples of terms that we would be looking at. But it's important just by clarifying those issues in the contract, that will help you retain control over your data and take action in the event of any breaches or misuse of data.
Thank you very much. I know, sort of in years gone by, of course, sort of software contracts, grant of rights clauses and the license clauses had loads of attention, and then people just slapped on a data protection boilerplate and that was it. But I think now, I don't know if it's fair to say, but there's almost more attention, I think, on the rights granted in the data than there is in the software, because the software is a bit more of a well-trodden course. And then there's all the derived data. So it's not necessarily the data you're providing, but sort of what flows out of that data when an algorithm is applied to it or some other use case, and the sort of rights in the derived data and how you define that, as well as the algorithm, and then of course, probably slightly outside the scope of this talk, but it's sort of AI regulatory pieces as well. So it's becoming super interesting. Aisling, do you when you're drafting some of these contracts, how often do you sort of liaise with your disputes team about how things can be interpreted? Do you do that sometimes?
Yeah, absolutely. And I think it is really important to consider, what can go wrong. Obviously, when you draft a contract, you hope that there never will be an issue with it, but I think it's important to think about what could happen later down the line. So it is important that if, for example, you're talking about data derived and who may own that data, I think it's important to also have, in your mind, how might a court look at this clause, or what might a litigator think of this clause and how it may be interpreted. So it's certainly worth thinking about, or getting litigation colleagues to have just a quick look through the clauses as well, just to get their thoughts as well. Thank you
very much. And James, just handing over to you from a UK and also sort of broader global dispute perspective. And I know obviously the telecom sector is again one of the key areas you work in. And I'm certainly in disputes in those sort of commercial tech contracts or telecoms contracts. Having a lien or possessing data was always a vendor's means of trying to get payment out of a customer, for example. So holding on to data and a vendor's ability to hold on to data was always been a key sticking point. But we may come on to that later. But we talked about those sort of employee contractor issues and only one aspect. But what other issues relating to data are you seeing and helping clients with in relation to disputes?
Well, yeah, as Matthew was saying, that sort of deliberate action point is a key thing that we see often and depending on what's been taken, what they want to do with it, how cooperative they are, as Matthew was saying, you're quickly going to court for an injunction and an order for delivery up. The other issue, I would say, just focusing for a minute on employees and contractors, separate to that sort of deliberate action where they're doing something for perceived leverage or commercial gain, is that human error, that basic human error part. And we see a lot of that even now. Employees sending the wrong data to the wrong place, spreadsheets full of sensitive data going outside the organisation, not being protected, wrong addresses, wrong details. Those kind of slips and trips, but are causing all sorts of issues for the organisation. And everyone will have seen those play out in public too. That's separate, if you like, in addition to the inadvertent clicking on phishing emails that obviously goes on and is becoming more and more sophisticated, more and more prevalent. So those, in terms of those kind of employee contractor issues, and just to add to that, we've spoken a bit already about AI, Gen AI solutions. We're going to see more issues in relation to the use of data and data security breaches if Gen AI isn't being used in accordance with corporate use policies. For example, how is it trained? What are the prompts and inputs? What are the outputs? How are they used? I think that's an area which is really going to come to the fore pretty quickly. And I think just to add to that sort of employee contractor piece that we've been talking about. What I'd say, just to add to that as well, separate to that employee contractor piece, I'd say there are a couple of other kind of key buckets, if you like, of issues that we're seeing. And to sort of briefly headline those, I'd say the first is performance issues. So that's how the data is processed, how it's managed. And that's kind of looking at a B2B situation, personal data, corporate data. So we're seeing issues around inadvertent encryption, deletion, so stuff isn't backed up properly or regularly, being not deleted when it should be, so stored on legacy systems, that's all still happening. System outages, so that sort of temporary or permanent inaccessibility issues, and more broadly that data isn't being processed in the way it should be contractually, and not protected in the way it should be either. So, technical measures aren't activated, they're not present, they're not configured or managed, and essentially the door's left open. So, and on that last point, what I would say is, a lot of reliance is placed on the contracts, and we've been talking about the contracts just then. But what we're seeing is there aren't, in all cases, those proper and regular audits to see what's, whether the contract in reality matches. Especially in circumstances where you've got multi-year contracts, you've got multi-vendor IT estates, and so who's managing, what, how, to what standards become very real critical risks, I'd say. So that would, I would say, those kind of performance issues. The other thing, as you've just been mentioning, Phil, actually, just on those contentious exits, because we do even now see those where a supply has been terminated or otherwise exits, and then getting the data back or transferred to a new supplier wasn't really considered fully or fleshed out fully at the drafting stage. And so that isn't spelled out, how it's going to be done, in what format, who pays, and when it happens, who owns what, as Aisling was saying. And that's especially when you've got a new supplier coming in, taking over, and you've got a system and a service to maintain. And so guess what? Disruption of the service happens, loss and damage happens, disputes happen. And we've helped clients in that situation as well, get injunctions and orders for delivery up to sort that out, essentially. And I think, again, looking at AI, you're going to see more of that, just given the heavy use of data and how embedded it is in the solution that's being provided. So we're just at, AI solutions, sure, the traditional ones have been around for ages. The Gen AI solutions adding on top, and I think, you know, adding all of that to the solution. I think when those contracts come to an end or come to transition, I think we're going to see some more of those kind of issues come up. Third is M&A that you mentioned, Phil, at the top of the session. You know, we're all seeing those issues where the target suffered a big data breach, and, you know, you're having to assess what impact that has on price and value. And I'd say the fourth one is you know, the cyber and security breaches that we've, you know, all worked on together. And I was writing a briefing just the other day about increased cyber activity from foreign state actors, for example, briefings to the public and private sector by the security service and government agencies. There's a lot of that cyber activity, ransomware attacks, all that sort of stuff is huge and persistent. So that's a bit of a quick canter, but I think all of those issues, I think, are present, persistent risks and stuff that we're seeing and helping clients.
Thank you very much. I'm particularly interested by and I think the having the right of audit is obviously you have audit to make sure people comply with software license terms, etc. But having rights of audit to verify compliance with data right usage clauses, for instance, and also the from looking through the regulatory lens, I know regulators are looking to get much more involved in looking at how data is being used and whether there's any bias in it. Of course, things like gambling regulators has done that for a long time to sort of make sure that random number generation is completely random, or that someone's selected as a winner out of a prize draw. But I think getting access to those systems and the right of audit and transparency is going to be very important. I actually just, as we're sort of you know, sort of breakfast time, and sort of what's sort of hot. Yesterday, I noticed there was the Digital Regulation Cooperation Forum, the DRCF, which is this new collaboration between Ofcom, the CMA, ICO, and FCA, has issued a statement about joint collaboration between Ofcom and the ICO, specifically around online services. And in the context of disputes, of course, how regulators interact and supervise and enforce issues related to data information is so key, and some really interesting themes that come out of that. I mean, I won't just touch on it briefly, but they've sort of identified they're going to have some collaboration themes and also identify companies of mutual interest, which makes me and probably clients very nervous. But it also talks about themes that they're going to focus on: age assurance, recommender or algorithm systems, proactive tech, sort of content identification, user profiling, behavioral ID, default settings, online safety and privacy, and also upholding standards. And one particularly interesting theme is there's about information disclosure and sharing information between regulators. And Ofcom, section 393 of the Communications Act, prohibits disclosure of certain information about a business without consent unless a statutory gateway applies. And similarly, the ICO under section 132 of the Data Protection Act prohibits the disclosure of confidential information about an individual business unless a disclosure is made lawfully. So there's sort of this, not only disclosure between businesses, but disclosure between regulators is going to be, I think, a key area people to be aware of, because firstly, different regulators are going to be sharing this information for purpose of enforcement, but they may on occasion also share too much stuff if they're not careful. So that also may be an area to focus on. But just coming back to sort of the themes for data privacy litigation, James, sort of what's your view on where things are currently and how might things develop in the context of data disputes and litigation?
Yeah, I mean, it's a big sort of question, I guess, and probably to unpack properly probably requires its own episode. But I mean, what I would say is, in terms of some headline observations, you know, we've got individual and group actions in whatever form related to data are a constant, and organisations, you know, large and small, whatever the sector, you know, they're seeing that. But I think the nature and extent of those issues and claims are only going to increase. And why is that? Well, one is, as you were saying, Phil, the regulatory environment is getting ever, you know, more complex and stringent. You're seeing that through data privacy law, cyber resilience, tech regulation more broadly, and that cooperation piece as well. And I think those issues are only going to, and the regulation is only going to continue to expand and evolve. I think that's one factor. The second is, as we've been talking about, AI, Gen AI, and that next phase of AI, AI agents are only going to continue to use vast amounts of personal and corporate data, and how that's used and protected will obviously be key. The third thing is cyber attack activity, as I've mentioned, more sophisticated, more pervasive. And I think the fourth thing is the claimant law firms. They're going to continue to be creative, as I was saying earlier, creative in how they bring actions and litigation funding, as Daniel was saying earlier, certainly in the UK and elsewhere, is ready and willing to help them do that. So I think there are a number of factors which mean that data privacy litigation in the UK and elsewhere is only going to get more in terms of frequency and complexity as we move forward. And it's interesting what you're saying about the information sharing. I mean, certainly on some of the data breaches that we've seen, there is that circumstances in quite a few ways where a number of regulators are involved in what has happened, depending on the corporate victim and which sector they sit in and what activities they're undertaking. So, I'm not surprised that there is a move for, which has been coming for a while, but greater cooperation and information sharing. It's only a trend that's going to increase too.
Thank you very much. And I think in the context of sharing of data and digitalization creates great opportunities and does provide for greater collaboration. But if not done well, it also does mean that data will go to the wrong place, or too much data will be shared, or that there's too many copies and it's not deleted and stuff. So there's unfortunately we're going to have to be working harder, not less harder.
Absolutely.
I'm conscious of time and also demands on your time. I was proposing to sort of bring this to a close, but before I do, I just wonder whether anyone else wanted to provide any parting comments before we signed off. I should take that resounding silence as a positive thing, and thank you very much indeed for taking part, because I know there's a lot of the issues we covered there in quite a short space of time, and I'm sure the conversation will continue. Thank you.
Thank you for listening to the Evershed Sutherland Legal Insights podcast.